Hello and welcome to Thursday's Live with Chug. My name is Neha Mahajan, Business Development and Outreach Manager at Chug LLP Attorneys and CPAs. It's Thursday, it's September 1, 2022. It's 11 o'clock Pacific time, 2 o'clock Eastern time, and we are live on YouTube, Facebook, and LinkedIn with yet another topic of discussion, this time with our attorneys from our LA office. And today we'll be discussing about humanitarian reinstatement. What can you do if you're waiting for your immigrant visas and the main immigrant visa sponsor passes away, that person dies? What happens to the petitions of those family members whose main primary applicant has passed away? Do they have any kind of hope from USCIS? Is there anything in the law that can help them and support them? US immigration system has been under a lot of flack for a lot of reasons, even prior to the pandemic. And the pandemic has only made matters worse, whether it is getting an appointment for consular processing or, H-4EADs waiting for their renewal of their visas, work authorizations, or if it is, a family member waiting in line for their immigrant visas to become current and for the processes to happen in time. Well, timely processing of visas is now thing of past, doesn't happen anymore. What it does do is cause a lot of uncertainty. And if COVID has taught us one thing, it is uncertainty, right? And sadly, for a lot of people, uncertainty can be life-changing. This is exactly why we will be discussing all the legal options available for humanitarian reinstatement. Joining me from our LA office is our partner and attorney, Gladys Gervacio. She's been with the firm for a very, very long time, very knowledgeable. And joining us for the first time on the show today is paralegal Toni Ordona from the LA office, from Gladys's team. Hi there, Toni and Gladys. Welcome to Thursday's Live.
Hi, Neha. I'm glad to be back. I was here 2 weeks ago, but I'm happy to be joining you today on this live session, of course, with Toni. Toni, you want to say a few words?
Thank you for having me, Neha.
Yeah, absolutely. Thank you, ladies, for making yourselves available, But before we get started with today's discussion, just want to, mention that this discussion, we are live on Facebook, YouTube, and LinkedIn. And the discussion that we're going to have is for informational purposes only, does not create an attorney-client relationship. If you do have a question for us related to the topic today, please type it in the comment section and we'll be happy to answer them live on the show today. If not, if it's an unrelated question or if you're watching us as a recorded version, send us your questions, info@chug.com. That's info@chugh.com. So Gladys and Toni, when I was researching about this topic, I really found it very interesting. COVID has definitely taught us that life is all about uncertainties at the moment, right? And I'm sure this question is on many people's minds simply because, immigrant visas, there's just humongous wait period for them, right? Whether it's employment-based or family-based. And humanitarian reinstatement does come in handy, but there are a lot of conditions, that apply with it that people are not familiar with. I want to understand, what is humanitarian reinstatement?
So, Neha, before I dive into what humanitarian reinstatement is, I just want to do a quick background that and most people probably know this already, that if you're a US citizen or you're a legal permanent resident / green card holder and you want to bring in family members to the US, what you file is the I-130, which is the immigrant petition for foreign worker. Now, if the petitioner dies, this I-130 petition dies as well, simply because you don't have a petitioner anymore. And this is where humanitarian reinstatement comes into play, because this is a relief that it's a discretionary relief that allows the principal beneficiary of an approved I-130 petition to revive or reinstate this I-130 so that he may still continue to immigrate to the US.
Yeah. Would you say there's a great need for humanitarian reinstatement at the moment, right now?
I think now more than ever, it's very important that people know that there is this relief available. we hear a lot of people lost loved ones, family due to COVID. And even now that operations are getting back to normal or the new normal with USCIS or with US consulate offices, there's still a huge backlog of processing cases, right? So some families have waited 20 plus years to immigrate to the US, and then all of a sudden they lose their loved one, their petitioner who's been waiting for them in the US. And they don't just, there's heartbreak, right? They don't just lose their family, they also lose their American dream.
Yeah. Yeah. Thank you, Toni, for bringing that into perspective because, for USCIS, for US immigration system, immigrants are really just a number. When they talk about immigration, they talk about numbers. These many people want to immigrate to the United States of America, right? What they don't realize is that behind these numbers, there are actual people, actual lives, actual families that want to be part of the American dream, right? And want to take advantage of the processes that are already in place. What are some of the basic requirements for applying for humanitarian reinstatement? Toni, if you could go in a little bit of detail, that'd be great.
Yeah, so like Gladys mentioned, the I-130 petition for alien relative must have been approved by USCIS before the petitioner's death. So it must have been approved already before the petitioner passed away. And then they have to submit a new affidavit of support from a substitute sponsor. So who's the substitute sponsor? They must be a US citizen, US national, or green card holder, or lawful permanent residents, must be at least 18 years old, and they must be applicant's qualifying relative.
Okay. When you say qualifying relative, who would qualify to be a relative in USCIS's eyes, at least?
So it's actually a long list.
Yeah,
So
Gladys.
it could be the substitute sponsor can be the principal applicant's principal / beneficiary's spouse, parent, child, could be the grandparent, grandchild, could be the mother-in-law, father-in-law, could be the principal applicant's daughter-in-law or son-in-law. It can also be a sibling, a brother-in-law or a sister-in-law. And lastly, can be the legal guardian.
All right. And, these qualifying relatives, if the qualifying relative's income does not meet, say, certain criteria that has already been set by USCIS, how does that come into play? Toni or Gladys, whoever wants to take this question.
Yeah, it's a good question because a lot of the times, they may have a qualifying relative as a substitute sponsor, but it may be an elderly relative who's no longer working or retired or never worked, right? If the qualifying relative's income does not meet the poverty guideline as required, they can get a joint sponsor. So the joint sponsor will also have to submit an affidavit of support. The joint sponsor must be a US citizen as well, US national or green card holder. Also, it must be 18 years old, and their income for their household size must meet the poverty guideline.
So when you say joint sponsor, could this be a friend or it has to be
Yes.
another qualifying relative or who?
So it can be a friend, it can be a family, a relative that is not listed under the qualifying relative as a substitute sponsor. So now you must meet the required qualifying relative relationship, but you can also get a joint sponsor that doesn't have to fall into that relationship that's provided by USCIS.
All right. This topic is quite dense, and I'm sure a lot of people who are watching us today, have these questions in their mind. So I'll be asking a lot of cross questions to you both. So, really, really off the hook here. But I just want to reiterate, we're 10 minutes into our discussion, almost 10 minutes into our discussion today, and we're live on Facebook, YouTube, and LinkedIn. If you haven't subscribed to our channels, please do so because, you'll know what kind of events we are planning and where to find them and what time we go live and all of that stuff. Also, if you have any questions for us today, please be sure to mention them in the comment section so we'll gladly answer them all. Also, a disclaimer, the discussion is not for legal purposes. This is for informational purposes. And all the discussion that we are having today cannot constitute as a attorney-client relationship. Gladys, in the beginning, you mentioned that it's USCIS uses the word discretionary. It's at USCIS discretion who they qualify for under humanitarian reinstatement, really. Although there are various guidelines available, I really want you to go into a little bit of more detail and tell us, what does USCIS mean when they say discretionary?
So it's a discretionary relief because USCIS may or may not grant the request. The principal beneficiary cannot demand it as a matter of right. You have to prove your case that your request warrants a favorable exercise of USCIS's discretion, which means that the pros in granting the request will outweigh the cons. And in making that determination, USCIS considers a number of factors, whether they want to exercise that discretion and grant you the request for humanitarian reinstatement. So one of these factors is the impact that the revocation of the I-130 petition would have on the family unit, which in particular would be the petitioner's family or relatives who are already lawfully living in the US. Are they going to experience some hardship? You don't have to prove extreme hardship. The threshold is not that high, but showing some hardship to the family in the US would be good for your case. Another factor that USCIS would consider is the length of time that the principal beneficiary has been living in the US and already in the US. Also, whether he or she still has strong ties to his home country. So if that person no longer has a residence there, or don't have family members there, USCIS will also consider that. USCIS will also consider the principal beneficiary's age and health. So if you're elderly or you have a health condition, you're in poor health, that you require constant medical attention, they will also consider that. And lastly, they will consider the length of time that the government has taken in processing these delays. And so you will notice that most of the applicants for this humanitarian reinstatement are those from countries who have experienced several years of waiting for a visa to become available. And those are nationals, of course, from of certain countries like the Philippines, India, China. So there you go.
Yeah, no, thank you for mentioning that. I mean, it makes it very clear that a humanitarian reinstatement is actually a privilege. It's not a right. So you can't demand that out of USCIS. USCIS will, continue with its due process to make sure whether an applicant qualifies for it or not. Yeah. All right. Gladys, just to further this, this is a relief. This is a great relief for beneficiaries when the petitioner passes away. They're already in a situation. Now, what happens if it's the beneficiary that dies and leaves the dependent family members behind? What happens then?
Okay, so all is not lost for them as well. Back in 2009, the Relief for Surviving Relatives Act, other people call it the Survivors Act, was enacted. You can find this in Section 204L of the Immigration Nationality Act. I hope I got that right, Toni. Section 204L. And what this says is if the principal beneficiary dies and if the derivative applicants meet certain conditions, they can still continue with their immigrating to the US.
Okay, so I'm always very watchful when USCIS mentions certain conditions. It's like that small conditions apply that you have on or danger warning on cigarette packets or alcohol consumption.
Read the fine print.
Yes, right. It's the fine print. So, Tony, I want you to get into the details a little bit. And what are the requirements for INA 204L relief for surviving relatives?
Yeah, that's a very good question. Like you said, you got to read the fine print. Not everybody qualifies, but for those who do qualify, it's awesome because they can still pursue their immigrant visa or their adjustment of status, even if the principal beneficiary or the main applicant passes away. The requirement is that at least one of the beneficiaries or derivative beneficiaries must have been residing in the US when the qualifying relative passes away, and they must continue to reside in the US. Now, when they say residing in the US, it does not require physical presence at the time of death. They just have to show that they have residence, established residence in the US. So, for example, if they were not physically present in the US because they were traveling for work or they were on vacation and they were outside the country, it does not interrupt US residence.
Got it. Okay, that's good to know. And who qualifies for Immigration Nationality Act 204L relief for surviving relatives?
Yeah, so there's a few of them. So there's the beneficiary of a pending or approved I-130 petition. So unlike humanitarian reinstatement, it requires an approved I-130 prior to the petitioner's death. Here
Yeah.
it can be, if the I-130 is still pending, they can qualify for this relief as long as they meet the requirements, even if the I-130 is still not approved. There's also available for derivative of a pending or approved employment-based immigrant visa petition. So derivatives of I-140 petitions, they could qualify
Okay.
for that. Beneficiary of a pending or approved I-730 refugee petition, T or U visa, non-immigrant visa holder, or derivative asylees.
All right. Thank you, Tony. I actually came across a case a couple of years ago, when the second wave of the pandemic had hit a lot of countries, right? I know from a lot of actually first-hand stories where someone who was on an employment visa, and for those born in India, the dates to get current it takes forever. There's an estimate that says 96 years at the moment, right? But definitely 10 to 15 years right there. There was a case where someone had filed for I-130 and the status was not yet adjusted, and the primary applicant, for I-140 and 485 application, they just passed away out of the blue, right? So what happens to the spouse and the children, who are not US citizens and who are in line with that primary applicant, right? So
Right.
I'm very glad that the law has this this 204L
Yeah,
section in
yeah.
Immigration Nationality Act that kind of helps these people. This is really good information.
Yeah, because especially for employment based, they lose their breadwinner of the family. They use the main foundation of their household. So it's great that if they can at least still pursue their immigrant status after, if they meet all these requirements, that would be great for the family.
Yeah, yeah. I mean, we hope no one has to go through it, but life is such. We have to account for all the uncertainties, and that's exactly why we're discussing humanitarian reinstatement today with our attorney and partner Gladys Gervacio and our paralegal Toni Ordona from our LA office. We're almost 20 minutes into our discussion today, so if you're joining us today and have a question for us, we're live on Facebook, YouTube, and LinkedIn. Please submit a question in the comment section. We'll be happy to answer them. Or if you're watching us as a recorded version, send us your questions, info@chug.com. That's info@chug.com. USCIS.com. So we spoke about, the who qualifies for relief as surviving relatives, but who are considered qualifying relatives, Gladys? If you would like to answer that.
Sure, sure, Neha. So the qualifying relatives is the deceased. I know we were talking about death and deceased persons a lot here on this topic, right? But the qualifying relative is the deceased relative who is one, the petitioner of an immediate relative I-130 petition, that could be the parent, spouse, or child, and also be the qualifying relative can also be the petitioner or beneficiary of a family-sponsored I-130. It could also be the principal beneficiary of a widower self-petition, or the principal beneficiary of an I-140 employment-based, petition. You have the T or U non-immigrant, the principal T non-immigrant, sorry, and you have the VAWA self-petitioner. And I hope I'm not missing something. You have the petitioner of the I-730 refugee / asylee relative petition. And lastly, the principal asylee that's granted asylum.
All right, all right. So thank you for explaining that, Gladys. Toni, we've understood the nitty-gritties that are involved and who qualifies and who doesn't. But when it comes down to doing the real paperwork, how do you really request for Section 204L relief or the humanitarian reinstatement? How do you actually go about it?
There is no specific form for the humanitarian reinstatement or for the survivors relief. Because there's no form, there's also no filing fee. It is a discretionary benefit, right? So you submit the request to USCIS that approve the petition, or if it's pending, let's say you're filing 485 with the application or based on the approved, let's say I-140, you submit the request with your 485 application. Then you also have to submit the supporting evidence that you meet the requirements that they've been physical, at least one of the beneficiary has been residing in the US at the time of the petitioner's death. You gotta show the death certificate of the qualifying relative, and then show maintenance of residence in the US until the time of filing. So when I say it can be any one relative, right? I had a case once where the derivative child was in the US on an F1 student visa, right? The parent is not in the US, but they meet the requirement because the child was physically present in the US at that time of death. So they were able to pursue their I-485 based on that requirement.
All right, that's really great to know, Toni. So there's no set pattern, and probably that's why it's good to speak to an attorney to get the right kind of an advice, so that the right kind of, those guidelines can be met, and an attorney can assess better how to proceed with the filing of a humanitarian reinstatement for that particular case, right? A little while ago, we were talking about this situation, and Gladys, I want you to talk to me in detail about it. An applicant who is on employment-based visa with their adjustment of status pending, the primary applicant suddenly dies. Now, in this case, what kind of options do dependents have? How do they go about filing for humanitarian reinstatement?
So in this scenario, this actually falls under the Survivors Act. So in this situation, the spouse, you said the principal applicant dies, right? So the spouse or his children under 21 years old can still continue with their I-485 application and still get their green card, provided that one of them reside in the US at the time of the principal applicant's death and continues to do so, as mentioned by Toni, like all those requirements. They have to meet those requirements for them to continue with their I-485. So it's still possible, right? They can still get their green card.
Yeah, I mean, I cannot even begin to imagine the kind of stress and the kind of situation a family must go through, especially under employment-based category. If they lose their primary breadwinner, and the primary applicant really. And I'm glad that the law has provisions to help and guide people, and we have attorneys, we have the expertise. So if you are in a situation like this, or know of someone who's in a situation like this and do not know what to do and how to go about it, please send us an email. We'll be happy to help. info@chuk.com. We have the right kind of experts in-house who can help you, who can guide you, who can do the paperwork for you, and who can fight for you. So info@chuk.com, info@chugh.com. This brings us to the end of today's discussion. Ladies, do you have any closing remarks?
Well, Neha, I think the key takeaway that we want you, the listeners, to have from this session is that there is hope, right? Even if petitioner dies or the principal beneficiary dies, all is not lost. You have options. I know it's a difficult time. You just lost a loved one. You're still grieving, and that's where we come into play. Like, that's why you want to consult your trusted immigration attorneys and professionals to guide you through the process.
All right, thank you. Gladys, Tony, you want to say something?
Yeah, I do want to thank you, Neha, for this session. I think it's very important that we educate people who watch this Thursday live, because this is one of those benefits that not everybody is aware of that is available. Educating people is very important, I think. Because it's discretionary, there's no processing time available, unfortunately. But like Gladys said, there is still hope. There's an available option. It can be resolved if they meet certain requirements, and they can still get their immigrant status or their green card. And so I think it's important that we spread the word about these options that are available to them.
Humanitarian reinstatement. It is that ray of hope when you think that everything has ended and all the doors to immigrate to United States have closed. Clearly not. There is hope, and we at Chuk will be happy to help you and guide you through the process. So this brings us to the end of the discussion today. Thank you, Gladys and Tony, and thank you to all of you who've joined us today from various parts of the world and United States of America. If you have any questions, I just keep saying this as a broken record, info@chuk.com, info@chugh.com. I will meet you next week with another topic, another discussion. If you have a suggestion of a topic for us, please send us an email or just type it out in the comment section. I'll be happy to take a look and create that into a topic of discussion and bring an expert on board. Until next week, this is your friend Neha saying goodbye. Stay safe.